Sure, thank you all to join the session. Warm welcome. Uh, in this session, the topic of discussion is the right to constitutional remedies, right? Right to constitutional remedies. आणि संवैधानिक उपचारों का अधिकार संवैधानिक उपचारों का अधिकार ये क्या कि ये इट इज देयर इन आर्टिकल 32 of the Constitution of इंडिया। ये भारतीय संविधान के आर्टिकल 32 में दिया गया है, ठीक है। और क्या है कि दिस डायरेक्टली अलाउज directly the citizen of India to knock the doors of Supreme Court, in case basic fundamental rights are denied. In case basic fundamental rights are denied. Okay. डॉक्टर अम्बेडकर ने इसे कहा था, डॉक्टर B.R. Ambedkar, the architect of Indian Constitution, chairman of the drafting committee of the Constituent Assembly, इनका कहना था कि this right to constitutional remedies for the citizen of India are the heart and soul of the Indian constitutions. Heart and of the constitution. क्योंकि इसी के माध्यम से क्या है ना कि all other rights become possible. All other rights are ensured by these basic fundamental rights. याद रखिएगा, डॉक्टर B.R. अम्बेडकर, द आर्किटेक्ट ऑफ इंडियन कॉन्स्टिट्यूशन, ने क्या कहा था राइट टू कॉन्स्टिट्यूशन रेमेडीज को? उन्होंने कहा था हार्ट एंड सोल, आत्मा और हृदय, राइट। अब ये फीचर्स क्या क्या आर्टिकल 32 में वो देखते हैं हम लोग। मेन फीचर्स देखेंगे हम लोग। Key features of Article 32. तो पहली बात तो यह है कि this allows the direct access to Supreme Court. यानी कहने का अर्थ हुआ कि you can bypass lower courts and go straight to the top court, and go straight to the top court, that is the Supreme Court. पहला फीचर्स ये हुआ. Second one, a duty to hear. Duty to hear. The Supreme Court cannot refuse. The Supreme Court cannot refuse to hear the case when a fundamental and when fundamental right is denied. The third point ये कि basic structure, मूल ढांचा जिसे हम कहेंगे. This right is a core part of this right becomes the core part of the Constitution, land of the law, and cannot be removed by law, and can't be removed by law, right? And next point regarding the features of Article 32, come to the High Court powers. Article 226 gives similar writ powers. क्या बैठेगा? Similar writ powers to high courts. For both fundamental and normal legal rights Okay. Then come to the types of writs. Writs होते हैं types of writs. 5 प्रकार के होंगे. 5 types. 5 प्रकार के. One is called habeas corpus. Habeas corpus. A very brief मैं आपको पिक्चर दे रहा हूं. Habeas corpus, to free a person who is locked which locked up by the government or police without a legal reason. Without a legal reason. And the second, it is mandamus. Mandamus. Now, to order a public worker office or office to do their legal duty when they refuse to work. When they refuse to work. And the third type of writ is provisions. To stop a lower court from taking a case outside its power or jurisdiction. And next from the fourth type of writ, statutory. Here what happens to cancel a wrong order, already made by lower court. And fifth kind of writ is quo warranto. Here, to check by what right, a person holds a public office. A public office, they should not have So this way we have talked of the Article 32, and Article 32 of the Indian Constitution deals with the right to constitutional remedies for the citizen of India. And Dr. B.R. Ambedkar, the architect of the Indian Constitution, the chairman of the drafting committee, took this Article 32 also for this provision of right to constitutional remedy for the citizens at the heart and soul of the Indian Constitution. There are 5 kinds of writs that we have discussed. Habeas corpus, mandamus, provision, certiorari, and quo warranto. And this way, if your fundamental rights, basic fundamental rights are denied, you can directly go to the top court, so the Supreme Court of India, avoiding the lower courts. That's all for the day. Thank you.